Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Hi everyone, welcome back to Legally Speaking. Today we are diving into DUI charges. So Richard, one of the most common questions we get is, can someone actually beat a DUI charge?
Great question, Mel. Well, beating a DUI charge isn't easy, but it's often possible. Depends on the circumstances. Each case is unique, and there are several defenses that could work. You just can't tell necessarily in advance if they will work. You can only make the determination after a thorough review of the police report.
So Richard, can you walk us through some of these defenses? Let's start with the basics. What if someone wasn't actually impaired?
Absolutely. If you've been charged with drinking and driving, it's often because the police believe your ability to drive was impaired. Often they haven't met you before, they have no context. But impairment isn't always due to alcohol or drugs. Some people may seem impaired because they're tired, they're ill, or have a physical condition, perhaps bad knees, arthritis, something that impacts their stability. Often it's accents that might make the person sound like they have a slurred speech to an officer unfamiliar with their speech.
That is so interesting. So just because someone seems impaired doesn't mean they were. What if the blood alcohol level was low? Is that a good defense?
Well, even if you're over the legal limit of 79, in other words, you blow 90 or 100, obviously that's over the legal limit, but the practicalities of the situation is that the Crown Attorney often would consider a plea to careless driving if their readings are in the 120s or less than that, depending on the circumstances, whether the person has a prior record, whether it's an accident, injury, or really bad driving, would all be factors. Sometimes the equipment used, the devices, the instrument used to measure blood alcohol concentration is not always accurate. There's two instruments generally used, the approved screening device at the roadside and the Intoxilizer 8000C at the police station. If the device is faulty or not properly maintained or operated, it can produce inaccurate results. If the police don't follow proper procedure, it can be grounds for challenging the reading. I'll give you an example, Mel. If people were to look at our YouTubes, they actually find the one. Our assistant has a drink of rum, I believe it was, swishes it around in her mouth and then spits it out and immediately does a breath test on the proper machine used by the police. The readings immediately are about 400 milligrams, which is sky high. But over the passage of time, you see in the video that within about 15 minutes, the readings go down to zero. Because what that instrument is doing is measuring the blood alcohol oral cavity, the mouth basically, and it still has the bits and pieces of alcohol, even though the alcohol is not in the person's system. So their results should be at zero, but the machine is giving a false high. In that situation, the case is generally called a quick alert. You see it sometimes where perhaps someone leaves a police station. You see it sometimes when the person leaves a bar. Perhaps they chugged a beer before they left because they didn't want to leave a half-empty beer. A couple minutes later, they get stopped by the police and they provide a roadside breath sample and they fail. Well, it may well be that that beer is not yet in their system. When the police know that the person just left the bar, just finished a beer, because the person who stopped mentions it to the police, or perhaps the police see a half-empty beer bottle in the console of the car, the police need to check and ask when the last beer or alcohol was consumed. If it's within 15 minutes, they have to wait for 15 minutes to go by, at which point they can do a test and the test would be valid.
So technical issues with the machine itself or errors on how the test was done could be used in a defense?
Yes, if the instruments weren't working out properly, or there was a delay between when you're pulled over and when the approved screening device test was done, or there was a delay in giving rights to counsel at the side of the road, can often be defenses. Could be that if you weren't giving your rights to counsel right away, it could be a pretty good effective defense.
And then, Richard, what happens if someone refuses the test? Could that ever be defended?
A person should never refuse. There is less defenses for refuse fail to provide, but there are still defenses. Refusing a breath test is often seen as an automatic conviction, but there are exceptions. For instance, the police don't have a lawful basis to demand the breath test, or if it wasn't clear that the refusal was being interpreted as a refusal, that might be defense. Or maybe simply that it's a bad demand. The police can't simply say, Melanie, would you please provide a breath sample? They have to make it a demand. Like, Melanie, I demand that you forthwith provide a breath sample into this approved instrument. If they simply ask or say, would you? It's a bad demand and the police would likely lose.
Okay, so there is a lot to look into if someone is actually charged with a DUI. But can we ever promise that someone will win?
No, Mel, we cannot make that promise. But the promise we can make is that we can't guarantee a defense. But if there is a defense, we promise that we will find it. We'll review the police report in detail, the Crown disclosure, the videos of the breath testing. We'll make sure rights to counsel was done properly, and we'll assess the case fully to see if there's any viable defenses. If you have a defense, we'll tell you. If you don't have a defense, we'll tell you that as well.
And I'm guessing that not all the defenses are listed here, right?
Exactly, Mel. It's not an exhaustive list. Sometimes we uncover new defenses after digging into the evidence. Other possibilities deal with privacy rights. Often when the people are at the police station doing breath tests, they're in the cell for a while, may have to use the washroom facilities. Sometimes the police do not provide a gown or a blanket so a person can go to the bathroom without being seen on video or closed-circuit TV. Often there's a screen used. But police sometimes forget, and that can be a major problem, an invasion of privacy rights, and a very effective defense, especially where the person is a woman. Sometimes delay in rights to counsel has to be given forthwith, which means right away. Delay in giving the approved screening device demand, again, has to be done forthwith. If the police hold the person too long after the breath test, where there's no basis for keeping them after the breath test, they keep them for 6 hours instead of 1, that can also help for defense. Every case is different. Our job is to find out the best approach.
Thank you so much, Richard. That was incredibly helpful. And remember, everyone, if you're facing a DUI charge, it's important to consult with an experienced lawyer. They can evaluate the specific details of your case and help you understand with your options. So thank you, everyone, for joining us today for the Aitken Robertson YouTube channel. Don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.